topic which we're going to discuss about is e-discovery and digital evidence, in which we're going to discuss about techniques for managing electronic discovery and using digital evidence in litigation, including challenges related to authenticity and admissibility. For that, I would like to call upon on stage Ms. Shalinee Kulshreshtha, who's a General Counsel at South Asia in Aegis Network India Private Limited. And she's the moderator for this panel discussion. And we have another one, which is Lakshmidevi Somanath, who's a partner, intellectual property practice at Surana and Surana International. And next we have Monika Tyagi, who's a senior legal counsel at Vikram Solar Limited. Guys, have a big round of applause.
Hi everyone, good afternoon. I hope the lunch was not so heavy and it's still going to be interesting, right? So we have, it's always the most difficult session, when you have to talk about something post-lunch, because people have had like a full sumptuous meal and they are like now looking for yawning and sleeping. But believe you me, this is going to be interesting, and on more than that, we are going to keep it engaging. So just so that we do kind of a little warm up, I thought instead of we starting talking on the topic, why don't we hear from you? What's your understanding of digital evidence? What do you think is a digital evidence? So can I have, some answers from the audience on what you think is digital evidence? Any takes on what is digital evidence? Any examples rather of not the definition per se, but any examples of what is it that you consider as digital evidence? Some examples of digital evidence. WhatsApp, yeah. Emails, yes. Photographs. Digital photographs, right? Yeah. Screenshots. Yeah. Sorry? Phone records. How about GPS location? Yeah. And then how about CCTV footages? Right. Call recordings, like your official team call recordings. Yes, anything else that I'm missing when we talk about digital evidence? Any other ideas on what else could be considered as digital evidence? Yeah. Sorry? Facebook, your social media accounts basically, yeah. Yeah, so I think we were first thinking of starting, this conversation by giving a very basic and fundamental understanding of what is digital evidence. But I don't think so in this forum. You need to know that because all of you already know. And this is basically what is digital evidence. So any data or information that is stored in digital form, and we spoke about a lot of examples of, digital evidence. So that is what is digital evidence. So we will start by that, and then of course take you through the various aspects of digital evidence here. But before we go there, I would like to check with my distinguished co-panelists if they would like to add something on what they consider as digital evidence and maybe elaborate further on it.
Yeah, I think there was some input from that table.
Yeah, absolutely. Yeah.
Yeah. So papers scanned and stored in a soft media, would that amount to digital evidence? It would. Yeah. So as per the definition under the Information Technology Act, all papers that are scanned or all information that is generated and copied onto an optical or magnetic media can be considered as digital evidence, and it is admissible. The normal trend that you see in the courts is that bring the original document or bring the certified copy of the original document. That has been the rule as regards litigation. But with the advent of modern means of storage of information, now digital evidence is admissible, And yes, it is considered as valid evidence by the courts.
Thank you, Shalinee. How about Internet of Things like smart watches? That they are also a piece of digital evidence that is accepted globally today. So this is my understanding of digital evidence apart from what has already fallen from the audience and my panelists here.
Sure. Thanks, Monika. Thanks, Lakshmi. So I will go to Monika first. And again, I have, I would say, the luxury of a very diverse panel because as you could make it out from the introductions, Lakshmi represents the litigation side of the law, while Monika represents the corporate side of the law in terms of, I would say, the areas of their expertise and the roles they play, on a day-to-day basis. So I will like to go to Monika and understand that if we have to look things from a corporate perspective, what could be a relevant digital evidence from corporate perspective?
Thank you, Shalinee. Good afternoon, everyone, and I hope everyone is awake to listen to us here. And so moving forward, so before being on the corporate side, I was part of the litigation for a good decade. But I have seen a huge difference from moving from, because my experience on the litigation side and understanding of digital evidence came totally different from what I see in the corporate side now. Because everything we do in the corporate industry is digitized today. Everything, every data, every from anything you can relate to is digitized today. We do not have anything on paper. We store it on our databases. So protection of the data and maintaining the confidentiality, etc., also comes into picture. And apart from that, even our contracts today that we execute in the organizations are everything which are happening on the digital platform. So if tomorrow we are faced with a situation where we have to go for, with respect to execution of contracts, etc., which are executed online or through e-contracts, etc. So they play this digital evidence is, of course, the primary thing would be to preserve it and how to really look forward towards its authenticity. So this is how digital evidence has to be taken care of for the longer run as well, because nobody is now working on papers. So on corporate front, this is my view of how I would like to present it.
Sure, thanks, Monika. So I would like to add, being a corporate lawyer myself, so when it comes to corporate world, I have experienced digital evidence being really, really critical. When I say so, of course, Monika touched upon the contracts piece. These days, we have everything in digitized form. And gone are the days when people used to have contracts, signed in blue ink. I know some companies still do, follow the traditional form of storing contracts, but I think a lot of, organizations are moving into the digitized world with the change and evolution of technology. I think the other things I've seen, getting relevant in corporate world are also videos, call recordings, or I would say CCTV footages. So if there is an internal investigation, there is a complaint against an employee by a whistleblower, in those situations I have seen digital evidence being so relevant when having, when doing an internal investigation on the subject. So that's another area where I see incorporate, digital evidence being relevant. So I will, shift the gear here and maybe move to Lakshmi and understand from her litigation experience that, which legislations, Lakshmi, would you say are crucial for one to have a good understanding of digital evidence in the Indian law context, and what has been your experience on the same?
Yeah, so, it's basically three legislations, as we all know. It's the Information Technology Act 2000, the Indian Evidence Act, and the Criminal Procedure Code. So the Information Technology Act deals with the reliability of the digital evidence, how exactly it should be submitted in the court of law. All those are dealt with under the Information Technology Act. The Indian Evidence Act looks at the reliability, admissibility, and the weightage that can be given to the evidence that is submitted. The procedure for the submission of such digital evidence is covered by the Indian Evidence Act. The Criminal Procedure Code, which of course lays down the rules regarding the general procedure to be followed regarding criminal trials and criminal cases, it lays down the manner in which such digital evidence can be considered. So this is a trio that exists in India as of now. The IT Act, the Indian Evidence Act, and the CRPC. CRPC as of now, but then to be taken over by another legislation very shortly. The same provisions are included in the legislation also. If you look at the extent to which the courts have interpreted the legislations, it is vast. They have gone on to broaden it in one particular judgment and then constrict it in another judgment that came subsequently that I would be dealing with in due course. So yes, these are the three legislations that exist in India as of now.
Thanks, Lakshmi. Yep.
You're talking about call records and WhatsApp, but right to privacy, how that have an effect on, if I suppose during any evidence now, most of all we don't, thank you, most of the times we don't write down the evidence, we just take consent from them, and either we have a video recording or we have an audio recording. Now suppose during this investigation, the witness also switches on his mobile and get it recorded there. How does that have, can she or he, the witness, can they produce that before the court in their defense? How the right to privacy would be affected by using this private recordings?
Sure, thank you.
So as far as these private recordings are considered, the very important aspects that courts looked at is how that evidence has been obtained. Whether the procedure, there is a procedure prescribed that you have to, there are two things, primary and secondary evidence. So when you are procuring an evidence, we have to prove that it has been procured with all admissible modes as prescribed and as accepted by courts. Like you said, that a witness in a court proceeding and is recording something, or as a witness is recording something for his benefits, it would be seen by the court if it has been obtained with all legal standards or not.
Just to add to what Monika said, 2001, State versus Navjot Sandhu. It was the parliamentary attack case where, in the interest of resolving the matter, the court went to the extent of saying that we would admit all phone records without a certificate under section 65B. But then came the subsequent case of Anwar versus Bashir, where they said that now we are going to, we would not be admitting digital evidence sorry, without a certificate of authenticity under section 65B4. So the courts have gone on to expand the scope of the statutory provision as it exists in the need of exigency. That is, they have been able to widen the provisions of the legislation as it exists, keeping in mind the need of the hour and equity and good conscience, but at the same time where it necessitates that it has to be accompanied by a certificate, as we always see. I mean, when you submit a digital evidence, it has to be necessarily accompanied by a sworn affidavit. Otherwise, it is not admitted by the court. It would be rejected at the section level itself. The court section would say that, see, no, you need to submit a sworn affidavit so that we can take this on record along with the other documents. So it varies. And as far as the right to privacy goes, it's a delicate balance between the right to privacy on one hand and the fact that, you know, somebody's, the private aspects of somebody's life, which is his guaranteed fundamental right under Article 21, is going to come to light through such evidence being submitted in the court. And at the other hand, what exactly is the stake in the matter at hand? Plus, the mode in which such evidence is submitted, as Monika just explained. So all these are factors.
I just want to ask, suppose a husband wants to bring a case of adultery, And from the wife's Facebook or WhatsApp messages or through call recordings, he brings some evidence to show that proof the case of adultery. Well, that has to be filed also with 65B affidavit. Now, how that can be filed with a 65B affidavit and how the court will take? Will it be regarded as entering into the Article 21 of a person's, like when she's talking with somebody, you are getting recordings of that, or in a Facebook, WhatsApp, private messages you are taking, then, but it is important for proving adultery of the wife also. It is important. So how to balance this?
So that would be, it would be a sealed record. It would not be open for public scrutiny. The court would order for the records to be sealed. And as far as the evidence is submitted in the prescribed manner, along with a sworn affidavit, then it will be admissible it would be admissible and it would be taken on record by the court. However, it would be sealed. It would not be open for public scrutiny.
Yeah, and I will add a different angle to it. First, adding on to what Monika and Lakshmi have mentioned. I think when it comes to someone who is going to commit a crime, and if you are looking for getting consent from the person, I am going to make your recording when you are committing crime, you are never going to get it, right? However, if you have the recording wherein someone is recorded committing a crime and it is produced in the court of law, the presumption would be drawn that it is, authentic and valid till the opposite party is able to prove the fact it is not, right? And it is corroborating, substantiating the case at hand, and that's why, it becomes relevant from that perspective. I remember dealing with one case, wherein an employee has initiated a claim against the company for wrongful termination and had produced the recording of the internal investigation. And dealing with companies wherein you have foreign stakeholders, the question was, how come the court can admit this recording when I did not even know it is being recorded and my consent was not obtained? It was like, if it becomes necessary for the judge to decide the matter or understand the overall situation, for them to look at the recording, then of course they are going to admit that recording. And it is more discretionary in the way how I would see it in Indian context. And again, I think data privacy or privacy in itself is an evolving subject. We still don't have DPDPA. I mean to say it has not yet been made effective, while of course it has been passed. So I think that may also change the landscape of how we see things in India. The other thing I would like to talk about is internal investigation from a corporate perspective. So what we normally do when doing an internal investigation, if there is an audio recording or there is a video recording, we would normally talk to, say, the other witnesses who either witnessed that conversation or were there when that audio or video was recorded. If they say, yes, this happened, say even 2 out of 5 say, yes, I remember hearing this person say this, then you put it in front of that person. And that person has to prove it that he or she did not say that, right? So that becomes so relevant from an internal investigation perspective. I have seen internal investigations taking a completely different turn when you have evidence in the form of, say, digital evidence for your internal investigations. So I think it is relevant, be it in litigation before the court or internal investigation, but again, it's very subjective in what situations would it be considered as admissible or not.
Just to add to what Shalinee said, it is hearsay. So all emails and text messages are essentially considered as hearsay evidence, which is not admissible because it is secondary evidence. And that is where the question of authenticity comes. So unless it follows the procedural rules, unless it is accompanied by a certificate of authenticity, unless there is a sworn affidavit, it satisfies all the rules, comes to the bench of the judge, the judge goes through it and deems it admissible. Until then, it would not be taken on record. And if you look at the various jurisdictions, both the US and UK follow India, are on the same lines of India. For example, in the US, the federal rules of evidence very clearly say that there should be, the importance is on the authenticity of the evidence, not on admitting all kinds of digital evidence in a case. It has to be authentic, only then it would be admissible. Same goes for UK. The Data Protection Act in UK says that an evidence has to be authentic, only then would it be admissible, the digital evidence. However, the situation is different in Europe. Europe, as per the GDPR, places a lot of emphasis on privacy. So there is a conflict between the evidence and the privacy, and privacy we see most often prevails. India, privacy takes a back seat in cases of necessity. If you can submit the digital evidence as per the statutory rules laid down by the various statutes, then yes, the evidence is admissible.
So Shalinee, just for my understanding also, now we have Data Protection Act in picture. How that plays, that interplay between the digital evidence and how we protect our personal data, like data we feed in on internet and even on links per se. How do we protect that?
So I think this is actually an evolving subject. We don't yet have the rules under the law. So we will have more clarity once the rules come into play. And interestingly, you know, as those of you who follow the changes in, you know, legislations, legal system may have seen, unlike a lot of countries, when we talk about DPDPA for India, we only talk about digitized, you know, personal data. We don't talk about personal data in the hard form. So we need to see, and I would say wait and watch when the rules come in, how it changes the landscape of digital evidence, and would it be that the data privacy law would, you know, take precedence over admissibility of digital evidence. So I think this is still to evolve, and this is not yet an evolved space for us to have enough precedents or judgments to talk about it. So let me go back to Monika because we are talking about digital evidence. So it's so relevant and important for us to understand how to, you know, how to manage your digital evidence, say in a corporate environment, for it to be ultimately admissible in the courts. What are, you know, some of the tips that Monika has to share with us in terms of how they manage their, you know, e-discovery and storage of digital evidence in, you know, the kind of companies or, you know, wheresoever she has worked. So would be interested in your thoughts, Monika, from your experience.
Thank you, Shalinee. So when you are in a setup of an organization, there is a lot of exchange of information, which even as employees you share externally. And a lot of external information gets fed in your mailboxes or maybe in your clouds for that matter. So it is very important to first protect your data. And how you protect your data is to maintain a chain of custody, like from where the entire, the first recipient and the sender of a particular email, etc. You need to have a good system with the organization where maybe softwares, there are so many softwares today we have available in the market today to support us on that, and to have a, like I always really emphasize on why chain of custody, because if we are not able to have that chain of custody, tomorrow my evidence will not be admissible in the court. It may not be primary or secondary, it will not be evidence at all. So it would be a very difficult situation for me, and especially in a circumstance and in a setup, we are not dealing with papers at all. So there are very minute checks that we keep in the organization, that how, apart from sending emails, and even the, if a particular, like an ex-employee of the organization has left, his data is still protected, is still available with the IT department and in safe hands. So it is not misused, and that the chain is still intact. That tomorrow if we have to utilize it for some XYZ reasons, may not be litigation always, maybe for some investigations, etc. It stays protected.
Thanks, Monika. So the, you know, kind of three-finger rule I follow when we talk about digital evidence is, you know, collection, preservation, and storage. In our company, we follow this rule that if in case you have collected data rightfully, legitimately, and have then preserved and stored it in a right way, then that's something that would help you when there is need for you to, have this evidence admissible in the courts of law. So, that's the kind of rule we internally follow. So I think it's more from a corporate landscape, how and what we do in terms of preserving or storing digital evidence in our companies. But let's also hear Lakshmi's thought on the conditions of admissibility of digital evidence in the court of law, because that's where ultimately you go through the test of scrutiny, and what kind of challenges she may have seen, practically in getting this digital evidence admitted in the courts of law.
So I think we kind of touched on this on the earlier discussions. No, I just wanted to go slightly 2 steps back to one of the questions posed here regarding the Data Protection Act. Right now it is a personal data protection bill pending with the Parliament. Reminds me of a story, Jataka story. So there were 4 brothers. I think many of you would know this. There were 4 brothers who had attended the Gurukul, completed their education. They were going back home. Each tremendously intelligent and wise and possessed of skills that no ordinary human being would probably have. So they came across the skeleton of a dead lion. And then they just wanted to, they had tantric skills, tantric skills was what they had learned at the Gurukul. So they wanted to test their knowledge. So one of the brothers said, let me do what education I have received, let me try to revive as per what I know. And then he chanted some mantras, and there were muscles that were formed on the skeleton. Then the second brother said, okay, now I'll do it further. And he chanted several other mantras, and then there was skin on top of the skeleton. And the third brother chanted all the mantras. And slowly the life merged into the lion. It was not dead anymore, but probably comatose. It had life, but it had not opened its eyes and woken up. So, as per the story, the 4th brother, when he says the mantras, he knows that the lion will get up and eat all of them, because it's been dead for a long while. When it's getting up, it's obviously going to be very hungry. So it sees 4 humans, it's obviously going to attack them. And then he says, no, I don't want to have any part of this. And he climbs up into a tree. The other brothers, overcome by their knowledge and not heeding the dangers that would be associated with it, say, okay, if he doesn't want to do it, let him not do it. Let's all 3 of us do it. And they chanted the remaining mantras, the last mantras. The lion woke up and promptly ate all 3 of them up. Now, why this story now? This bill has been pending. It was introduced by the Parliament in 2019, and it has undergone quite a bit of back and forth, with comments being called for from the public on various aspects. Now, the Data Protection Privacy Bill would essentially protect all data of citizens, including digital data, which then needs the courts and the government and investigating agencies to strike a delicate balance between what can be taken as digital evidence and can be admitted, and what cannot be. So there are various data that can be garnered only by obtaining the consent of the person. Further, on the same lines as the GDPR, the present bill also proposes a data protection authority that would look into the fact as to whether the necessary permissions have been obtained. So there is a balance that has to be maintained between both the laws. Otherwise, then it would be the same situation as the lion coming to life and then eating everybody up. there would not be any balance between the laws, but only chaos. Right now, there is a lot of emphasis being placed on digital evidence also by various investigative agencies, but unless they follow the rules of the book, most of the evidence would turn out to be inadmissible in a court of law, as per what we see going on now, the particular procedures that they follow.
Yeah, I think it's so interesting, and you know, why don't you elaborate and help, you know, maybe elaborate on a point that may be relevant for those of us who are from corporates, because when we are working in corporates, our role ends when we have, you know, kind of collected, preserved, and stored the data. But when testing the testimony of that digital evidence in the court, if you were a lawyer representing the other side, and you know there is the lawyer, the other side basically relying more on digital evidence, what kind of, you know, questions or, you know, scrutiny would you put them to make sure that there are questions raised as far the authenticity or credibility of the digital evidence is concerned?
So first thing would be the certificate of admissibility, as we already discussed here. Second thing would be the chain of custody, as Monika just elaborated. How exactly has the evidence gone from hand to hand? And the third one would be the meta-authenticity. What exactly is the time and date stamp? What is the recipient information? What is the sender information? What are the details regarding the read and delivery receipt, if there are read and delivery receipts? All that would be looked at to verify whether the evidence being submitted is authentic or not.
Sure. Thanks, Lakshmi. So let me move to Monika now. And I think it would be good, Monika, to hear some tips from you that you would like to share with the audience in how do you manage digital evidence in your company?
Like I've already touched upon this topic like while I spoke previously, but I would still reiterate that as supporting views of my fellow panelists also, that chain of custody is a very important aspect. And when you're in an organization, I'll tell you a very basic example, like even from like an employee's point of view, we are governed, we have our system and database with respect to our in and out on a particular day, from how our entire working and our ethics are monitored in a database. So right choice of a particular software and proper maintenance of that particular data is how we govern the entire even work ethics in our organizations. So yes, maintaining a chain of custody, and of course not considering it to be, because it's about storage of data. Some of the data will be relevant, some of it would be irrelevant, but not deleting which is irrelevant would equally be beneficial to you at some stage of time, because it would come out as a helping hand at some stage when you enter some sort of investigation, etc. Yeah, that would be my advice.
Sure, thanks, Monika. So coming back to you, Lakshmi, can you discuss the evolving standards or precedents in India regarding the admissibility of digital evidence before the courts?
Yes, Shalinee. So two cases which I mentioned. One is State versus Navjot Sandhu. Yeah, the next is Anwar versus Bashir. So State versus Navjot Sandhu was the case dealing with the parliamentary attacks where mobile phone recordings, the admissibility of mobile phone recordings was in question. The Supreme Court said that yes, it can be admitted as evidence, even though a certificate was not there, and it was admitted as evidence. Then in 2008, we have the case of Anwar versus Bashir, where the Supreme Court, held that no, you cannot admit digital evidence unless it is accompanied by a certificate stating that this is genuine. That has been the change from 2000 to 2008. And the most recent case of 2020, the Kishore case.
Anwar versus Muhammad. In that case, the court said that.
Yes. Yes, in Anwar versus Mohammed, the court said that, it again backtracked and it said that not really necessary, a certificate of authenticity, but now the latest position, 2020, the Kishore case, the court very clearly says that it cannot be admitted unless there is evidence of genuineness under Section 65B of the Indian Evidence Act. So that's the position as of now. Which brings me to another story from the Jataka tales. There was this mother-in-law and daughter-in-law who lived together. So night time, the daughter-in-law just stepped out to do some household work and all that. She heard two beings speak to each other, and let's go to the island that's full of golden sand. And she was wondering, what is this? And she was standing near a tree. Suddenly the tree started shaking and it started flying. She was standing just next to it, so she clung onto the tree. The tree flew for a very long distance. She was so scared. So she was petrified and in shock. She just clung onto the tree and did not speak. Finally, the tree touched ground. Whoever was on the tree, she saw them flying away. She understood that they were not humans, but some other beings, probably Rakshasas. She stepped onto the sand and found that the sand was gold. So what she did is, she scooped as much of the sand as she could in her sari pallu, and she found a hollow on the tree. She got into it comfortably and sat there waiting. Both of them came back and they lifted the tree and brought it back home. So by the time it was morning, she immediately ran inside very happy and told her husband and mother-in-law, see what I have got, it's like gold sand. The mother-in-law, as usual, was very unhappy. She said, only this much? How? I mean, if I had gone, I would have brought back the whole island. You just brought some 3-4 scoops of sand. This is the way to do it. Okay, next day night, I'll do it. The next day night, she went and stood near the tree. As usual, both the beings came and said, come on, let's go. She climbed into the small place in the tree where she could sit, and they landed in a place. And both the beings flew away. The mother-in-law then got out and looked at the sand. The sand was ordinary. She thought, aha, my daughter-in-law has tricked me. This is not the thing. And she was very furious. And she was also furious at both those beings who had not brought her to the island of gold. She was waiting, fuming. She was thinking, let them come back, let them come back. Once they came back, she said, how dare you bring me to this island? And they said, who are you? No, yesterday night my daughter-in-law came and you took her to a golden island and she brought back the gold sand, and today you have brought me to some other island. They told her, this is not Swarna Deep, this is Machli Deep. Only fish is available here. There is no gold sand, so we cannot take you there. And the mother-in-law kept arguing and saying that, no, it is not possible. They said, see, where is the evidence? Have you brought that sand with you? You are saying that your daughter-in-law went to an island full of golden sand. Where is the golden sand in your hand? She said, I don't have it, but my daughter-in-law went there and there is an island. What did those two beings do? They are cannibals, Rakshasas. They ate her up. So, I know it's a very long-wounded story, but to come to the point, unless the evidence is there, and not only should it be there, unless it is properly presented, it would not be admissible. And in a court of law, you would get eaten up by the opposite side. There have been cases which we have fought where the parties did not even argue on merits, but the arguments merely stopped at the admissibility of evidence stage, because all the crucial evidence that had been submitted were deemed as inadmissible because they were not termed as genuine and not accompanied by a certificate. So that is the importance that following the statutory procedure lays down.
Thanks, Lakshmi. So I'm cognizant of time and I wanted to definitely have some time for questions. So maybe we will stop here and, take some questions.
On a lighter vein, in all the stories shared by Lakshmi, someone is being eaten up, for sure.
Yeah.
Hi Lakshmi, hi Shalinee and Monika. Okay, I'm Vasundhara Prasad. I'm an intellectual property lawyer. I was speaking at the panel earlier, yesterday. We had two panels, one on ethics and one on artificial intelligence and its repercussions or its synergy with intellectual property law. This is not related to that. I'm talking about the panel that you're heading today. Do you have scenarios, because I'll ask you, Lakshmi, I'll present it to you. Do you have scenarios where the organization that you're representing has been asked to provide decryption keys to the government under the Information Technology Act 2000, and it does not have the barrier for intermediary, or corporations? And secondly, do you want to comment on the very recent discussion or the recent case that has been decided by the Delhi High Court under the privileged, auspices of Justice Pratibha Singh on Neetu Singh versus Telegram? So first the decryption keys and then the Telegram case. How do you, how do you analyze it, and what's your take on providing decryption keys, and how effective have you been in providing them?
At least I have never been asked, so I'm not in a position to comment.
No, neither in my organization, not as of now we have faced that situation.
So Lakshmi, do you have?
Lakshmi, you can put a light in respect of law.
Yeah, so in the case of Neetu Singh versus Telegram, the court went into detail into privacy vis-a-vis the admissibility of evidence. So taking into consideration the exigencies of the matter at hand, the evidence was taken on record. But there have been various cases. There is another case that is pending before the Delhi High Court, Chaitanya Rohila versus Union of India, which would also look into aspects of privacy vis-a-vis the Data Protection Act once it passes from a bill into an act. How exactly do you protect the information and identity of individuals on social platforms, not just social media, but also anything that the public can access? Do they really have privacy rights over that? That is one of the key concepts that the Data Protection Act is going through a 50-50, where the view has been raised that if you have already handed over all your data to public platforms, where it is viewable by all and sundry, then what privacy rights do you have over such data, is one stance. Whereas the other stance is that if it is my data, it is under my control, and therefore I do have privacy rights. This is a way in which I would like to portray it, but that does not mean it can be used in other senses. So all these are questions that would also be examined in the Chaitanya Rohila case, which is pending. A conglomeration of the jurisprudence in all these cases would give us the way forward in the years to come.
Yeah, that's good. The point that I wanted to touch upon was the territoriality of digital data. That's very important, because if you're dealing with an organization which is, which has its servers somewhere based in maybe Texas, and it's regulated or it's registered under the Cayman Islands, what's the stand that it has in India? And that's what Justice Pratibha Singh cleared, that the territorial integrity is very important to keep. And the Indian court does have the standing in terms of dealing with all these matters. So they can't just hide behind Cayman laws and behind Texas law and say, okay, you guys have to come to this particular jurisdiction and not present your case in India. So that's what she clarified, which was very landmark, because earlier it never happened.
Yep, thank
More
you.
of a domain of conflict of laws, etc.
Do we have one last question? Okay, if not, I would like to thank you all so much for being such wonderful audience. And I would also like to thank my co-panelist for being such wonderful co-panelist. Thank you so much, everyone.
Thank you, everyone. Thank you.